Great. So thank you for having me. I want to talk a little bit about the theme of how AI is changing a topic that I've been studying for some time, which is research exceptions within copyright law, which we've been framing as the right to research. I'm not going to give kind of the human rights background of this, but every copyright law since the dawn of copyright law, I would say, has had research exceptions built into the fabric of copyright law. And research is a lot of what we're talking about in the AI field, right? The first step of creating a machine learning program is to make a whole lot of copies. And sometimes we call it text and data mining or computational research or whatever, but we're using computers to study that content and try to extract information out of it. Whether you're creating, in the case of generative AI, possibly new expressive works, or whether you're just trying to find facts. Internet search to some extent is just a big text and data mining application. So to give an example, so this is charting not AI, but uses of text and data mining computational research in the academic sector. To get this information, we did a computational research project. So we went into Scopus and we negotiated with them and we got access to their back end. And we used an algorithm to do a search and searched through how many of the methodologies in Scopus databases was defining a text and data mining or computational research methodology. And so they're academic articles. Some of them may be related to commercial projects, but it's published work. We have some other charts in other places. This is just the wealthiest countries. You can see Germany is the one that's spiking out off the charts here. But there's thousands of articles being published a year in Africa and Latin America, etc., using these kinds of methodology. And it's meant to flag to us that whatever we're doing in the AI space, potentially, if we're not using kind of surgical precision, is also going to affect what academics are doing in the scientific research space. The protection of scientific research is mentioned in the first copyright laws. Neither of these two laws, the U.S., I'm citing the Constitution, but the Act of 1790 or the original Statute of Anne, since we're here in the UK, neither of them included what we would consider exceptions today, right? It was the main exception was a deposit. I was just looking over the Statute of Anne just now, though, and the deposit rule in the Statute of Anne says that it must authorize the use of the work by the library. So it uses that term use, which I'll in a minute define as an open term. It doesn't say reproduction. It doesn't say you can only put it on your shelves. I don't know where's Lionel? Lionel will have to tell me in the questions, how is that actually interpreted and used in British libraries? I think it named 7 or 9 different libraries. Cambridge was one. So I don't know if they were making reproductions or, what uses they were doing. But the terms of the Statute of Anne use that open term. In the original Berne Convention, there's one exception in the 1886 version of the Berne Convention. And recall, the Berne Convention doesn't actually have a right to reproduce until much later. So it's predominantly a publication right. But it includes in that original French version of the Berne Convention a right to extract portions from literary artistic works for use in publications destined for educational or scientific purposes. Again, I want to engage Lionel in the questions about how this was used, because I'm guessing in the 1880s, there were no copy machines. So I'm guessing the uses, they're using printing presses probably. They use this particular word, I don't even know if I can say it, which is like a collection of works, collection of articles, examples. If you look up Wikipedia, have like collections of works by a particular author or something like that. So I'm guessing, I was chatting with Henning about this yesterday, I'm guessing that universities were publishing collections, right, to train their students, to train their researchers, research institutes, etc. But the important part is that education and research were on the mind of the negotiators. It was actually the German negotiators that insisted on this. If you go back to the records of the Berne Convention, it was Germany that was saying, and they actually said they were going to block the Berne Convention if it didn't have exceptions for research in particular built in. So moving up, there's no quotation right in the original Berne Convention, but we're here in Cambridge. We have Tanya and Lionel with us, so we need to talk about global mandatory fair use. And in describing what they mean by comparing this clause to fair use, they use a lot of the language that I would use as well. So like the US fair use right, it applies to all works. So it's not just broadcast works, it's not just literary artistic works, right? It applies to all of the rights. So it's not just a reproduction right. It applies to all the different rights that are protected under the code. It's not limited by purpose. Quotation, I would say, is a type of a use. It's not a purpose. You can use the quotation for the purpose of research. You can use the quotation as a purpose for parody, whatever. So it's a quotation for any purpose. In the summary that I was reading from, they don't mention, I don't think, maybe I didn't get to that part, but it applies to any user as well, right? So it's not a particular kind of user. You don't have to be a teacher. You don't have to be a librarian. You don't have to be a member of an institution. But it's not quite as broad, they say. I want to use the phrase open as US because it's not every act. It's not every use. I called attention to the Statute of Anne uses the term use because I think that's the broadest term. Actually, a use and a dealing, I think, are the same thing since we're here in the UK. But this is just a right to quotation, not a right to all uses. So, of course, it wouldn't apply to most of what I just said computational researchers need. Computational researchers don't quote. They make copies of whole works. So I think under most definitions, that's not itself a quotation. So you would need to go broader than that to find enough flexibility to do this kind of research. So many years ago, this is a pretty old study, but Mike Palmetto and I were originally set out to study what's the impact of fair use. And so we had to decide, well, what's fair use? And fair use has what we call openness along all those dimensions, all the dimensions that the quotation right, but it applies also to the user, but it applies also, most importantly, to the use, any use. It's not just a quotation. It's not just a reproduction. And so we use the term together, openness, to refer to that. Some people call it the breadth, generality, flexibility, but we try to define those, and I'll use these terms specifically in my talk, but openness means openness on all of those different dimensions that you could constrict exception to the works, to the uses, to the users, etc. We use the term flexibility to point to there's also a four-part test that you use to apply, a proportionality test. And when we use the term generality, we mean that one exception can apply to multiple kinds of different uses. So fair dealing and fair use for that are the same. And I think the benefit is you can draw a similar case law. But so using this terminology, there are 12 countries in the world that presently have open general exceptions. I would say they have the same openness as fair use. I have a slightly different list than Neva in one of her articles, because a couple of these, Canada, Brazil, Ecuador, some people think they're interpreted as open, but if you read the terms of the text itself, they don't look open to me. There's some countries, of course, moving in this direction. But it's important to see from the list, they're not all common law countries. This is not a function of just common law. There are civil law countries as well that have open exceptions. For instance, Thailand has one that doesn't talk about fair use or fair dealing. It doesn't derive from a common law kind of system. It just uses the three-step test, flips it, and makes it an opening clause. So you can get to open a lot of different ways. It doesn't have to come from a particular legal family. Then now moving into the topic of research. So if you accept that kind of criteria and you say, okay, we're not so interested in how open the exception is to all purposes like fair use. So fair use by the magical word such as, it doesn't apply just to research, but it mentions research and scholarship right in the text. So what other exceptions around the world are as open as fair use to the specific purpose of using it for research? And so now we identify a bunch of different limitations. So sometimes instead of the word use, you only use the word reproduce. So then you may not be able to share the work with another person. You may not be able to display the work. You lack the other rights. You only have the right of reproduction. Sometimes you have a restriction just to a private use. So now you're talking about the right of just an individual. Sometimes the right, instead of being an individual, is in an institution. So you have to be at a library or a school or a university or a scientific institution or something like that to have this right. If you're outside the right, then you lack it as an individual. Sometimes not all works are included. So many research exceptions say you can do whatever you want with an article, but you can't make a whole book. You can't copy a whole book. So think of it in a text and data mining concept. So now you're only using articles, but you're not using books. Or sometimes there's no uses of works. Oh, this is my favorite one. Sorry, Hungary. Hungary, you cannot make a copy of a complete book unless you do it by hand. Then it's okay. So this is a map of the world, static, at the end of 2020, I believe, of how open research exceptions are around the world on these various axes. So only the greenish countries have what we would call an open research exception. So here in those green countries, you should have, at least on the face of the statute, a colorable argument that at least for an academic research project, a scientific research project, you could do a text and data mining project. You have the ability to make copies of whole works by any source, any kind of work, by any user. You don't have to be a member of a particular institution. In the red countries, you only have the global mandatory fair use. You have a right of quotation. But here, looking at the ability to try to make copies of whole works for a computational research project, that global mandatory fair use is not fair use enough. It's only an excerpt right. It's only a quotation right. So it doesn't get you into this kind of research. And then again, the restrictions on types of works, restrictions on private reproduction, and then yellow restrictions on sharing are important. In the yellow countries, you actually have a pretty good right if you're an individual, but because it only applies to just the reproduction right, not the sharing right, you may not be able to do any kind of collaborative research. So if you're researching with people in different institutions, especially. So this is what the kind of world looks like. So if you're thinking, okay, what does copyright look like? Where can we do these kind of modern research mechanisms? The answer is, less than a quarter of the world. How are things changing? So we also looked at this research in the same data set and went over time, about a 20-year period, and looked at how research exceptions in particular are changing over time. And the answer to that is that you see an uptick in the higher income countries, but in most other countries, as they amend their laws, there's actually a trend to make them more restrictive. So to add a restriction on types of works, to add a restriction on the type of user, to add an institutional restriction, etc. But it's contrary to kind of the rhetoric in Geneva, right? I mean, the rhetoric is that it's the poor countries that are freeloading on the rich ones. But that's not in reality. The reality is the rich countries have more open exceptions. We've done another work like this where we look at all kinds of exceptions, and it's even more dramatic. You see a big variation between developing countries and rich countries, or rich countries are moving more dramatically towards what we call more open exceptions over time. But this is before AI, or before Gen AI, before AI becomes kind of controversial in public. I think we stopped this at about 2023. ChatGPT was 2024, I believe. So more recently. Just a couple examples of maybe how things are changing in a different direction. So taking the UK, for example. So if you bracket 29A and you just look at 29, 29 is pretty much an open research exception. It's got a non-commercial restriction, but other than that, it applies to every work, every user, any research purpose. It says use, I believe, or dealing. It says dealing. Dealing means the same thing as use. So it's going to cover all protected rights. So potentially, and it's just has to be fair. So as long as you can make an argument, for instance, that your collaborations are fair, I would say you'd be able to share works in between collaborators. So you've got a pretty good research exception. But then as it moves into the particular topic of text and data mining, again, I think this was passed before the generative AI, and I know there's now debates here about maybe making it more restrictive or not. It's going both ways, I guess. But here it becomes slightly more restrictive as it becomes more specific. So now it's just making a copy. It's not any use. So what can you do with that copy? Well, you can't transfer it to another person. So it makes it a little more restrictive. Maybe you can't do collaborative work. It still has the non-commercial restriction. It's just reproduction. It's not other rights, etc. So that's one trend. Another example of a trend, Brazil. This one kind of goes both ways. So Brazil in our map was red. Brazil only has a quotation right. Brazil's only right that applies to research is the uses of excerpts, and it's law now. So as it moves, and this is just a bill, it's not passed, the first thing they do is modernize the research exception part and make it much broader. So the automated use of protected content, indexed and data mining for the purposes of research and development, as long as it's done by institutions. So just these kinds of institutions. You have to be journalism, museum, archive, library, and educational organizations. So they can do it. If you're not one of those, then you both have an exclusive right. The owner of the material may prohibit the use for another, so you can opt out. You can pull it out of the system. And you have a remuneration right. So it's definitely not a free use. It just kind of puts that right in. This is not a transformative use. This is not a free use, particular for commercial uses. So where should we go? So we started with Bern. I might end with Bern. I'm spending a lot of time in Geneva these days. There's a agenda item going on in the copyright committee there about creating principles and objectives for a new instrument on limitations and exceptions. What's the next instrument that should come after the American? Murray mentioned the broadcast treaty. There might be a deal. If the broadcast treaty moves, then maybe something on limitations and exceptions is going to move too. And what should the research component look like? So one idea is maybe it should look something like this, that it shall be permissible to engage in research uses of works, including for scientific study, search, organization, and analysis of data, to the extent consistent with fair practice. So what are some elements of these? First of all, it's open in all the ways that I described. Doesn't restrict it to particular institutions. It uses the term use, research uses, not just reproductions, for instance. It gives some examples to guide you in a particular direction, and then it completely punts the non-commercial commercial distinction. You just have the fair practice there. So countries can decide for themselves through an adjudicatory process or whatever, the extent to which this would apply to commercial AI products, generative AI products, etc. And that's kind of where a lot of the legal debates are existing today, certainly in the United States, where you have a open textured exception, but that doesn't mean it's all lawful. It means you have an argument. And so those arguments are taking place now to the extent to which that will apply to different of these kinds of AI projects. So maybe it's extending a bit of the US approach into the international law. And I'd be happy to take questions and criticisms on that one. Thank you.
Right. Dave, just picking up on the thing that's on the screen at the moment.
Sure.
Should you also have to acknowledge the source?
Well, I would possibly. I mean, I think, if you look at the UK law, for instance, they say you have to acknowledge the source unless you don't. It seems to be in all the exceptions. And so I think you could read that into fair practice. I mean, that's what we would do in the US. So in the US, fair use right doesn't specifically say you have to acknowledge the source, but through the case law, if you don't, then it starts looking more fair, but it's more of a standard than a rule. I like acknowledgement. I mean, I don't have any opposition to putting that in. In fact, one of my big critiques of ChatGPT type generative AI systems, just from a researcher perspective, is because it doesn't put the source. I have to know when it's hallucinating. We talked about hallucinating before, and when I do stuff in my field, I can tell. So it once told me, ChatGPT, the first time I used it, told me that it was the original. I was trying to do something on the original Berne exceptions, and I said, what's the interpretation of these original Berne exceptions of 1886? And it said, the Berne Convention of 1886 created the concept of fair use, and fair use turns on 4 different factors. And blah, I was just like, okay, put that in your international law exam and you will fail.
Similar question. What about unpublished works?
Unpublished works is very interesting for archives. I don't have a problem with using unpublished works. Many laws require that something be published. That hits some real problems. So I was in South Africa recently, and the University of Cape Town had a fire in one of their libraries, and it burned a whole bunch of their archival materials. And I was asking them, well, how much of this was digitized, before the fire? And they said, well, we lost all of our original manuscripts because they're unpublished. And the exception in our law for library copies only applies to published copies. And so we didn't digitize any of these copies, So my inclination would be to apply it to unpublished works as well. Again, you can do a lot of work in fair practice, so it doesn't need to authorize you to publish the unpublished works, but should you be able to do research with unpublished works? For sure. That's why we have archives.
I wondered if you had a view on whether there should be a Berne understanding of fair practice, or whether you would leave this entirely to Berne Union members to determine what is fair practice.
I would leave it entirely to individual countries to determine what's fair practice. I mean, the thing about WIPO, of course, is it's all countries together. It's a consensus-based body. So whatever you get done there has to be kind of broad enough to encompass the legitimate debates in between legal systems, right? So which elements of fair practice could we say are consensus? I mean, maybe we can have something around attribution, but I would want it to say attribution to the extent possible or something like that, I mean, you start getting these hard rules and it is very hard to comply with. How do you get remuneration in, remuneration where it's necessary, or, I tend to, there's versions of this or versions of the thought where you can really start getting into, okay, substitution is an important factor, right? One of, I think, the distinguishing points between generative AI and research-based computational research might be that the generative AI has more of a possibility to have a substitution effect. But, which ones and how much is, has a lot of interrogation to do. But if you start writing these pieces in, it may be hard. But yeah, the fair practice, I mean, I would start with something that probably looks like a fair use test would be a good way to start with it. It's like some factors to consider that are fairly broad. Those have been adopted, in a lot of variations of that kind of tests have been adopted in a lot of the fair dealing and fair use countries. It might be a good starting point. But there'll be a lot of countries that will resist it for that reason. The term fair use in WIPO is like, kryptonite, or toxic. People don't like it.
Partly for that reason, suppose there is a new treaty or limitations and exceptions. What's its relationship going to be with Bern?
Well, it can be different things, right? I mean, you could actually go through the process of including it in Bern, but that we haven't done that for a long time. It used to be that Bern was revised every, decade or 20 years, and it was kind of updated at each step. But I think it was, and actually the 1996 Internet treaties, the World Copyright Treaty and WPPT were started as being that. But then they decided to make them a special agreement. So now it's kind of a parallel agreement. Most likely in reality, it's not going to be a treaty. It'll probably be like a joint recommendation or something that's a little more soft law-ish, although there are countries that want it. Henning. Oh, sorry.
Just on the point of relationship burn. So
Yeah.
as you said, like WCT and so on, there in Marrakesh as well, there's special agreements in the Article 20 burn, which means they must not be contrary to burn, there's two alternatives, either not be contrary to burn or provide stronger protection. So this wouldn't provide stronger protection. So you would have to read this as being compliant with the three-step test, but Marrakesh basically is doing the same thing, right?
Yeah.
And it has various references, as you know, to the three-step test, and similar later treaties have as well. So you would probably understand if you could get consensus in WIPO to do this, that would serve as a reinforcement by application and state practice to what the three-step test actually means in Word or TRIPS perhaps as well.
Yeah, I would definitely accept that.
We've got time for one more. Yes.
You mentioned that this provision might apply differently to different AI projects. You mentioned generative AI as one example of a different type of AI project. And at the start of your talk, I think you mentioned that the TDM, text and data mining, is about sort of the extraction of facts. And I wondered if you had a view on, given that it seems from where you were going, I got the impression that you were suggesting that TDM allows the extraction of facts, and it's kind of the facts and the analysis of those facts is the important bit, and copying of expression in that process is kind of a necessary part of getting to those facts. I wondered whether you had a view on whether TDM type exceptions should apply in cases such as generative AI, where arguably you're not copying facts so much as the expression that you're going to take forward.
This debate is going on in Japan right now. Japan has the most artful exception in this area, if you've ever seen it. But it's to paraphrase it, it says it's lawful to use any work as long as it's not for the emotive content in the work. It's not to enjoy the emotional content in the work or something like that. And so if you're only doing something to create something else, it's kind of a version of the transformational use concept. And then, which generative AI tools are kind of recreating that emotional content, for the purpose of enjoying that part of the work. I think that becomes a factual basis. So we're working with some AI developers in Africa, for instance, that are using the same kind of ChatGPT type tools, but they're creating translations. So they're trying to create new texts in underserved African language. So translating English into Tswana or Ndebele, I think Ndebele doesn't even have a Wikipedia page. It's so under-resourced. And they're actually using translations of the Bible in order to train their systems. Because you have English and you have the translation. But the translations are made by Jehovah's Witness, and translations are copyrightable. So the Jehovah's Witness claim a copyright on their translations. And on the page, it specifically says we don't want them to be used in text and data mining projects. So now these researchers who are in Kenya and South Africa and Ghana and Nigeria have this question of like, does that apply to us? So it's pretty much generative AI. This project is actually non-commercial, but what if they wanted to make it commercial? What if it was a commercial entity? What if somebody wanted to sell a tool, an app that you could plug onto your phone and translate all the news into Tswana? Do we care? You know, how do we interpret fair practice here? So I think to me, that's a different question than if you're creating like a music program and you're going to digest Sting's work and then you're going to create music that sounds like the Police. Now, that seems very substitution effect. But this other one, I don't think there's a substitution effect at all, right? You're literally giving an app that people can't read the English news and they want to translate it into, you know, their language. It's using all the AI tools. It's I don't know if it's generative. It's just translation. But I think there's a whole bunch of individual ones like this. And I frankly would try not to determine them with very specific language. Like Brazil, I think this is a problem. So it just says you build an AI system. Once you build an AI system, then any owner of copyright has a right to exclude. So what does this mean to me? I mean, one fear, I understand what this is going for. A lot of artists have like a moral opposition to using their own work to feed the robot that's going to displace them. That's how they feel. So they want to be able to take their works out. But if you give a right to exclude, who benefits from this? It's not the Brazilian AI producer. So now Elsevier has the ability to come and say, no, you can't text and data mining my scientific articles. Why might it do that? Because the Brazilian AI producer might not pay enough, right? So they would love to have this right, but they might only license to Google, Microsoft, OpenAI, people who can really pay. They might not care about the little people in developing countries. This is what we see with medicine pricing. Just charge everybody the same price. If they can't pay, they don't care. Make more money by charging a high price. So if you have that, then I think actually the ones who benefit here are the big tech people who can already do it, who can either afford to pay the data or are sitting on it. So I'm very worried about kind of exclusivity. Remuneration, I'm not always as worried about remuneration, but if I was drafting this, I would make it regulated remuneration. Let a government set the rate of remuneration. But this is imagining market setting the price, which I think if you're in Brazil is very dangerous.